Deputy Desdi Ellis. Are you sharing time?
No, what have I got, 10 minutes?
Well, you've 10, there's 20 minutes in the speaking slot.
Well, I'm taking 10, I don't know.
Okay.
Okay.
Jane O'Mail.
Go round Mahagut. A dús bara, Bawatlam Falcha her Higam Billa Shaw. In Mohuram, Tashe on Tabak her fod. It is the case and has been the case for quite some time that the family, as understood by those who framed our constitution and those who were at the helm of the state for decades, is a faulty, outdated and ultimately useless idea which betrays more about the social conservatism of those who espouse it than it promotes healthy family relationships and good law. Irish social policy has been profoundly damaging in regards to its approach to family, on children, on women, and even on men, particularly some fathers. This bill is a major moment for reform of these wrongs, but like steps in the right direction, it is not without its flaws and limitations. One very disappointing thing about this bill is that we have had to wait so long for something so basically fair, something which simply allows for people to live their lives and be a family with fair recognition by the law. It is particularly shocking it has taken this long when you consider that the shortcomings of the state in this regard have touched every family in the 26 counties. We have all been victims to a much greater or much lesser degree of this prevailing ideology of denial and repression of our humanity, when expressed outside the clearly defined lines handed to us by those who were often better at acting piously than they were living as such. But we cannot blame this government for the failings of previous governments, and so we welcome this bill. Certainly it is better to have these reforms later than never. It is very unfortunate that the bill comes so close to the campaign for equal marriage rights for same-sex couples. This has given those who wish to muddy the waters, confuse the public and sow misinformation an opportunity that they have leapt upon. If you listened only to some commentators who are invited on TV and radio to trot out antiquated notions of how men and women should live, you would be easily led to believe this bill was seeking to deny children parents, to remove rights from people, and to cast Ireland into some kind of immoral mire on which the sky would surely fall. The reality is that there has always been and always will be same-sex couples in Ireland. They are no different by and large from any other couples, and they have now for some time been able to adopt, although not formally as a couple. This legislation will formalise their ability to be a parental unit to their adopted children, and so provide children with a recognised two-parent family under law. This is not an insignificant piece of legislation either, in what it seeks to achieve or the depth to which it goes into on these topics. So I do understand these things cannot be rushed. With over 170 sections, it provides an extension of guardianship, custody and adoption rights to different types of families. Now couples who live together, regardless of their gender or sexual orientation, will be able to provide a loving home for a child. That is what family means in 2015. It is not about laws, genes, religious rights or strict ideas of how people should live. It is primarily about a loving home, especially in the case where a child is involved. This bill and the ideas behind it are not about gay rights, but all are equal, all are rights as equals to have, and to be part of a loving family and to have that recognised and respected rather than denied and vilified for not meeting someone else's code. I welcome also that this bill deals with leave for parents in cases where leave would previously have been unavailable or difficult to obtain. Despite all these positives, the bill fails to go far enough in ensuring fair and equal treatment of fathers in relation to disputes over custody. While adopted children's rights must be protected and enhanced, most children who have been affected by Ireland's failure to update family law have been children born to unmarried parents. The problem has not been that their parents were not married, but that the state was ill-prepared to deal with the legal outworkings of these relationships with regard to custody. Even when the state had stopped locking up unmarried pregnant girls, it was still woefully short of treating them fairly, with compassion, or including the father, their rights and their responsibilities. Children being born outside of marriage are 10 times more common today than it was the last time these issues were dealt with in the Irish law in the 60s. The result of this is the lack of any rights for unmarried fathers. While women in nearly every case in our society are structurally disadvantaged compared to men, in the case of family law, guardianship and custody, men can get first-hand experience of gender discrimination. This, I believe, is a result of a society that saw children rearing as women's work. And this attitude has not been updated in our law, despite the emergence of divorce and separation rights, as well as becoming more common for children to be born outside of marriage. Fathers are now a very real victim of this discrimination, and so are their children. Conservatives who said divorce would mean bye-bye daddy didn't know how right they were, but it was their own outdated notions of family, of men and women, of mothers and fathers, that would allow this problem to develop. The law simply ignored how society was changing and the new challenges it needs to deal with. Governments and the political elite ignored it also, as they were wedded to these conservative notions. Colette Brown yesterday wrote an excellent article dealing with the issues of fathers' rights. She perfectly describes how on a daily basis this lack of right impinges on a father's ability to care for his child and also damages the child. She writes, "It means that if your partner is away and your child falls ill, you cannot authorise medical treatment. It means that if your relationship breaks up and your partner decides to move abroad with your child, you are powerless to stop her. It also means you have no automatic right to custody or access to your child. By law, the mother is entitled to sole custody of the child if the father has not been made a guardian. Imagine a worst-case scenario in which your partner dies and you are left alone to care for your child. You would have to mount a court battle just to be entitled to care for your own child." This is not a new story. We have all heard of these battles by fathers over the years to have rights to be a parent to their child. But it has taken a very long time, and still we have not concluded the matter. This bill does seek to address this issue, and I welcome that. Unmarried fathers will now be given automatic guardianship rights if they have lived with their child's mother continuously for a year, including 3 months after the birth. But why the cohabitation requirement, and such specific ones that it would seem rule out many fathers who should have that right? The Law Reform Commission in 1982 advised that there would be an automatic right to guardianship, yet 33 years later we cannot even do that still. This not equality and perpetuates discrimination against unmarried fathers. The Minister describes this as a test of responsibility, but in some cases for a father to have their own place separate from the mother in order to keep their child from the difficulties they may have is often the most responsible thing they can do. An unmothered father's rights should not be hinged on the ability to live with the mother of his child. In other cases, it is simply not a possibility. This bill operates in a reality completely separate from the one which we are living in the midst of, a housing crisis, where young people cannot find housing for any reasonable price or quality in most cases. Should the conditions of the home suffer so that a father can cohabitate in order to get their rights to guardianship? This requirement has the potential to cause much familial strife and strain. Fathers who this bill will not help can supposedly be given rights through a statutory declaration, but there is no register of these documents in place and no plans to have such a register. Resources are always to blame. Sinn Féin and my colleague Patrick McLaughlin have been clear on this issue. We need a register to provide protection for the statutory declaration documents, which grant guardianship rights to unmarried fathers in respect of their children. Sinn Féin has raised other issues with this bill, which we will seek to correct in further stages. The family law courts are in need of serious reform and modernisation, as well as better resourcing. At present, they are not equipped to deal with the more family law cases that arise.
Thank you, Deputy.
Low-income families must also be provided with better access to the courts in the case where they do not fall into the bracket for free legal aid. We also want to see the establishment of a comprehensive court welfare service. This would organise the carrying out of assessments of a child's welfare and best interests, ascertain his or her views, while also carrying out family risk assessments. It would also ensure, where appropriate, that supports and services are available to the child and family, such as mediation services and child contact centres.